Welcome back to Sunrise Daily. We've got His Excellency Wike, Governor of Rivers State, here with us on the program today. Thank you for coming on the program this morning. Well, about this court judgment now, there's been several reactions about this, but yes, the PDP did go to court and then got a judgment in his favor. But if I could even start this way, getting this judgment in your favor, does it make you breathe easier in the context of the contestation between your party and that of the APC?
Well, there's nothing different. There's no difference about it because this is not the first time we've had an election with APC. And the truth of the fact is that we have always defeated APCs.
No, but you may have elections without APC this time. Maybe.
As far as we're concerned, the only problem we've had is that when there's election is the role played by the security. It's not because of APC. So there's nothing to talk about it. APC, for me, in this state, does not exist. But it only exists because of the role the security has always played in supporting APC.
But you challenged the process that brought about the emergence of the two candidates of the APC after they went through the primaries. So what is your own stake now as we lead towards the 2019 general elections, where you're also contesting?
We did not challenge the process that led to the emergence of APC candidates. We're not interested in who are the candidates of APC in the various elections. Rather, what happened was that we felt that, look, you have to comply with the provisions of the law. Of course, if you look at Section 87(1) of the Electoral Act, and then you looked at Section 66(b) of 1999 Constitution, Section 221, Section 106(d) and Section 1776 of the 1999 Constitution as amended, what we merely did was to go for interpretation that, look, for you to sponsor candidates for election, there must be valid or lawful primaries. And so if the court has said that APC did not conduct any lawful or valid primaries, are they supposed to participate in the general election? So we're not talking about candidates of APC, no. We're talking about the compliance with the provisions of the law.
So your case wasn't with APC. Why did you go to court? Because they will tell you that the emergence of any candidate or the choice of a candidate for any party would, by whatever process, legally of course, has to be the process or the determination of the party itself.
No.
PDP had no business in this case.
No. What we're saying, we're not talking about candidates of APC. We're talking about, look, the law says you must comply with certain provisions for you to participate in the general election. And the way of saying that, look, this party has not complied with the provisions. And therefore, INEC, if this party has not complied with provisions of the Constitution, can they still be recognized to participate in the 2019 general election? And what is provided in the fourth alterations of the 1999 Constitution, Act number 21, Act 2017, which says that a political party can challenge INEC if INEC is not complying or carrying out what they are supposed to do. And that's why we came in through.
But if this was any other political party, would the PDP have gone to court?
If there's any political party that has not complied with the provisions of the law, and we know, of course, we'll do the same thing. There's nothing special about it. We're an interested party. We have complied. We have carried out our valid and lawful primaries. And so we expect you, as a political party, you must also comply. And if you don't comply, then you cannot participate with us.
So the APC, at this point, is challenging the competence of the court to hear this case?
Yes.
How do you view that? I mean, it's one of the reasons that they gave, the competence of the court to the jurisdiction to hear this case, one, yes. And then looking at the suit and also the proper commendations that came out of it. So for them, this case could go beyond where it is at the moment.
Well, if you may permit me, so sometimes people do not give out the true situation of the cases, or the facts of the matter.
Even if it is before the court?
Yes. Now, let me just, for example, let me just cite something. Now, first of all, what did we go to do in court? It's important. Right. So many people have not had the privilege of reading the judgment. It's just mere comments. Oh, this happened, PDP did this and that. Now look at what we go to do. We went to court merely for interpretation. What we were asking, we were saying, upon proper interpretation of Section 87.1 of the Electoral Act 2010 as amended, Section 221 and Section 65.2b, Section 106D and Section 1777 of the Constitution of the Federal Republic of Nigeria as amended, whether APC, being a political party seeking to nominate or sponsoring candidates for 2019 general election into these offices, they are entitled to nominate or sponsor candidates without having a valid and lawful primaries for its aspirants, without having a lawful and valid primaries.
Did they not have?
The court should interpret the sections of the law, the Electoral Act, and the Constitution. 2, in view of these sections of the Electoral Act and the Constitution, can the INEC still allow APC to participate in view of the fact that they have not complied with the provisions of the Electoral Act and the Constitution of not having a valid and lawful primaries? Thirdly, in view of the judgment of the State High Court that had nullified the primaries of APC, which means there was no primaries ab initio, having nullified the primaries, can they still be allowed to still feature in the 2019 election? Now, what is their own contention? That contention is that, look, these are internal affairs of the party, that PDP has no business. We're saying, no, it has gone beyond internal affairs of the party. We're not interested in who becomes a candidate. We're talking about you complying with the provisions of the law. And if you don't comply with the provisions of the law, then you are not allowed to participate. We are not saying that this should be your candidate. That's not our business. And in doing that, we came under, if you look at the judgment of the court, if you look at page 16 of the judgment of the court, and it is important for people to understand, not just necessarily when you hear stories, oh, PDP went to court. Remember, on the 10th of October 2018, the State High Court modified the primaries of APC. 10th of October. You remember? Now, you also remember that APC went on appeal against this judgment of 10th of October to the Court of Appeal. Remember that. Now, also remember that the purported candidate, Toye Cole, sought leave to apply to appeal for that judgment as an interested party, because as at that time, he was not a party in the matter. Also remember that their so-called party chairman, who is a wanted person by the court, who is supposed to be facing multiple murder trial, who of course they are allowed to say that he stood for chairmanship of the position, also applied for leave to appeal that judgment. And they did that on the 23rd of October, 2018. Now, but if you look at the fourth alteration, number 21, out of 2017, it allows that, what is a pre-election matter, you must apply or you must appeal within 14 days of judgment given. Now, judgment was given on the 10th of October, and the so-called candidates of APC and their chairmanship candidate, in quotes, applied after 23 days.
So they didn't seek leave to apply?
After 23 days. In which case, you have applied out of time. Now, when they got to Court of Appeal, the lawyer of the other people of the other side of the APC filed a motion to say, look, this appeal they filed is incompetent. Why? Because the judgment that was given was a consent judgment, and therefore they did not seek leave of court before they appealed. And two, that even those who are seeking to join to appeal, they have done that outside the time, and therefore the appeals are defective. And the Court of Appeal, presided by Justice Tata Abubakar, said, yes, you are out of time. And that appeal was struck out. And the main appeal against the judgment of 10th of October was dismissed on the point that they did not seek leave, since it was a consent judgment. Therefore, the judgment of 10th of October, given by State High Court, is still valid there. which have appealed against the Court of Appeal and lost. Now, what did we do as a party? People said, look, if there was no primaries as held by the court, can INEC still allow these people to participate in the general election? The answer is,
okay.
They cannot allow them.
But let me follow up on some of these points that you raised now, because if you look at the judgment of the 10th of October, the Justice Nwogo's, if you look at decision 8 of that particular judgment, because where it says a declaration B and is hereby made that the primary is conducted by the respondent, the APC, in Rivers State for the governorship, Senate, House of Reps, State House of Assembly, and or whatever is done, howsoever done in conjunction with or with the participation of all persons elected in the ward, local government, and state congresses held by APC in Rivers State, all for the 2019 general elections based on the congresses conducted on May 12th, 19th, 20th, and 21st of 2018, including the election of the ward executives, local governments, it goes on, and it says, of the respondents, then, let me move to this one where it says, by any other person in the suit. But the argument now that the APC has, because remember there are two groups, apart from the Tony Cole group, the Abe group are saying this particular decision 8 of this judgment, those who committed these infractions were not those who participated in the indirect primaries.
What is about this? That is the judgment of court, and that's why you have gone on appeal.
Yeah,
and you have lost it in appeal. What's my business?